I'm George Curtis. Welcome to It's Your Law. Each week, it's my privilege to bring guests that discuss with all of us some things happening in the law and some things that they think should happen in the law, how laws are made, enforced, not enforced, and how sometimes they have some unintended consequences. Today, we have a couple of experts in an area that should concern all of us. It concerns drinking, driving, our drinking culture, safety on the highways, the judicial system, the prison system, and a real problem that we have in the state of Wisconsin, probably worse than any other state in the union, and that is the drunken driver. Our first guest is our district attorney, who is a hands-on man when it comes to that problem. Christian Gossett, welcome to the show.
Thank you, George.
Well, for the first time in a long, long time, the legislature has faced the issue of our drinking and driving problem. Why has it taken so long?
I think you hit on it in the introduction. It's part of our culture here in Wisconsin. Wisconsin, of course, is the drunk driving capital of the world. And the last significant legislation that came about for drunk driving involved going from 0.10 blood alcohol concentration to 0.08. And if you remember during all of the debates about that, Wisconsin went kicking and screaming. The only reason we put it in place was the Fed said, we're going to take your money away for highways if you don't do this. And so one of the things that's promising to me is in this round of legislation, this is going into effect today, by the way, or July 1st, I guess, by the time this airs. But with this new round of legislation, we weren't forced to do this. So I'm pleased to see the changes come about, I guess, more voluntarily, and I think part of that is the cultural shift.
Well, the changes are very, very significant, and I think perhaps we should begin with something that many people are confused about unless they've had the experience themselves. Normally, first offense, driving while intoxicated, is not a crime in the state of Wisconsin, unlike probably 49 other states.
Correct.
And it hasn't been a crime in the state of Wisconsin all by itself, unless it results in a death or something like that. There are still instances under the new law where it's simply a traffic offense. Can you explain?
Yeah, under the new law, almost every OWI first is still going to be civil. The one exception is going to be an OWI first with a minor passenger, somebody under the age of 16 years is going to be a criminal offense. All other OWI firsts will be civil still in the state of Wisconsin. We'll remain the lone holdout in the nation.
Is it still just a civil traffic offense if the blood alcohol is high?
It's still civil. If the blood alcohol concentration comes back at 0.15 or higher, there will be an additional requirement now of an ignition interlock device. But it won't change it from civil to criminal.
Those ignition interlock devices, they're expensive. How are they implemented and how do they work?
Well, they work phenomenally well if people actually utilize them. The ignition interlock devices are going to be required basically during the period of revocation. So if somebody's revoked for a year, then they'll have to have the ignition interlock device in their vehicle for that period of time. The big problem we see is that oftentimes people don't get them because of issues like the expense of it. Perhaps it wasn't their vehicle. And there's actually a bit of difficulty with this new legislation, and that when you get to the criminal OWIs where the ignition interlock device is required, there's two provisions that I think are going to create some difficulties for people. One is that they will be required to report to jail at sentencing, so there won't be 60 days to report. The second requirement is that they can't get Huber while they're incarcerated until they have the ignition interlock device installed. And right now, I believe the nearest location to get an ignition interlock device is in Appleton.
Who pays for it?
The defendant pays for it. There are provisions for indigent defendants, so at a certain income level, there's, in theory, money to offset those costs for those people.
Now, say I'm convicted of OWI, which I want to say, in case I ever run for office, hasn't happened. I also want to confess it could have happened. But at any rate, I'm required to have this ignition interlock. It's installed in my car. How does it work? If I go in and I've had any semblance of a drink, my car won't start?
Your car won't start, correct.
And I suppose there are people who try to get around it by borrowing their mother's car.
Yeah, people will borrow other cars. The worst situations we see are where people will then take their children with them so their children can blow into the device to start the car because the device can't tell who's blowing into it. So if somebody else blows into the device, the car can still be started. But in theory, it's effective.
Give us a kind of a general overview of the changes in the law, because they really are significant. And on the other end, the extreme end, the severe cases, you can become a felon a lot quicker. There are mandatory jail sentences, so they're getting serious finally, aren't they?
Yeah, it is better. With a first offense, we already kind of talked about that when that'll be criminal and civil. Second and third offense OWIs, in Winnebago County here, we've had a program called STOP. It's a Safe Streets Treatment Options Program. And before the enactment of this law, in Wisconsin, you couldn't be placed on probation until you had a fourth offense OWI. The big problem that we had with that is if you can't put somebody on probation, then you can't really force treatment. They serve a short jail sentence, they're out. The underlying alcohol issues are still present. So with the Safe Streets Treatment Options Program, in Winnebago County alone, we've been allowed to essentially put second and third offense drunk drivers on probation with treatment requirements. That's now being taken statewide. It's also being extended to fourth offense OWIs, and they also backed it up and said now for second, third, and fourth OWIs, you can also put people on probation. So we can finally do treatment alternatives or forced treatment through probation with our second and third offenses. With OWI injury, it's always been a misdemeanor unless it was great bodily harm. An OWI resulting in great bodily harm was a felony in Wisconsin. Now, if somebody commits an OWI injury, some minor injuries, but they have a prior OWI, that's now going to be a felony in Wisconsin. When we get to the fourth offenses, what we've also seen for a shift is it used to be that you had to get to a fifth offense OWI for that to be a felony. Now if you get a fourth offense OWI within 5 years of the previous OWI, that matter will be a felony. So
in short, the penalties have gotten tougher. The courts have more tools. They have an additional option. Yep. The hope is to let the public know we're serious about drunk driving. We're going to take a break and try a new guest and get an opinion as to whether it's going to make any difference, whether we can stop people from drinking and driving.
Very good. Thank you.
We'll be right back.